How does a lawsuit work? Hi, my name is David Price, and I'm a personal injury trial attorney in Greenville, South Carolina. I dedicate my practice to helping injured people, and I want to share some valuable information with you. Obviously, during the course of my practice, I file a lot of lawsuits. And one thing I find is that when people come to see me, they often don't understand the lawsuit process and are not sure what to expect. So I thought I'd take a minute and explain the process to you. A lawsuit is commenced when the plaintiff's attorney files documents with the court called a summons and a complaint. A summons commands the defendants to appear in court and participate in the lawsuit, and the complaint sets out the facts that are the subject of the suit. If a defendant ignores the summons and does not appear in court, he will lose his right to contest liability in the case. More often, a defendant will retain an attorney who will file an answer with the court, which is the document that sets forth the facts alleged by plaintiff that the defendant either admits or denies. Typically, if a defendant hires an attorney, he's not going to admit liability in the case. So the next step in the process is for the attorneys to participate in what we call discovery. Usually, the attorneys will first exchange some requests for information, called interrogatories and requests for production. The interrogatories are written questions from one attorney to the other, requiring that party to provide answers to those questions. The requests for production are requests from one attorney to another for copies of documents. After written discovery is over, the attorneys will typically take depositions. Depositions are where the parties to the lawsuit and other witnesses may be required to come to a lawyer's office and appear in front of a court reporter and to answer questions from the other lawyer under oath. This is the process by which the lawyer learns what that witness will testify to at trial. In most counties in South Carolina, the parties will also be required to participate in what's called a mediation. A mediation is a meeting between the parties and their attorneys at another lawyer's office, and the other lawyer, who has no relationship to the case, will go between the parties and help to try to facilitate their reaching a settlement or compromise of the claims. More often than not, lawsuits are settled, whether they be at mediation or in other negotiations between the attorneys. But when a lawsuit's not settled, the final step in the process is the trial. The trial is where the parties and their attorneys appear in court before a judge and try their case in front of the jury. The jury then makes a determination of whether the defendant is liable to the plaintiff, and if so, for what amount of money the defendant would be required to pay the plaintiff. That, in a nutshell, is the litigation process. In Greenville, it usually takes between 14 months to a year and a half from the date the summons and complaint is filed to the day the parties get their trial. In other smaller counties, it may take even longer because they may have less terms of court. My name is David Price, and I handle these kinds of cases every day. If you've been injured by another person, then I want to help you. Please call me at 864-271-2636 or visit my website at greenvillelegal.com. I will give you the personal, dedicated representation that you deserve.